Hello, and welcome to my presentation on Roper v. Simmons 2005. The first areas we're going to talk about are the legal questions, case background, and the history. First, and most importantly, the legal question in this case is it cruel and unusual punishment to execute persons for crimes they committed before the age of 18? Two other questions that came up in this case. The first being, once the Supreme Court holds that a particular punishment is not cruel and unusual and barred by the 8th and 14th Amendments, can a lower court reach a contrary decision based on its own analysis of evolving standards? Another important question, is it the imposition of the death penalty on a person who commits a murder at age 17 cruel and unusual and thus barred by the 8th and 14th Amendments? The background of this case. Christopher Simmons was sentenced to death for the murder of a woman when he was 17 years of age. In this case, Simmons devised a plan to murder Shirley Crook, bringing two younger friends, Charles Benjamin and John Tessamere, into the plot. The plan was to commit a murder by breaking and entering, tying up a victim, and tossing that victim off the bridge. The three met in the middle of the night. However, Tessamere then dropped out of the plot. Simmons and Benjamin broke into Mrs. Crook's home, bound her hands and covered her eyes. They drove her to a local area and threw her off a bridge. Prior to this offense, Christopher discussed with his friends his desire to kill someone by breaking and entering into the person's home, robbing the person, tying that person up, and then throwing that person off a bridge. He told his peers that they could get away with the murder because they were minors. Once this case was brought to trial, the evidence was overwhelming. Simmons had confessed to the murder, performed a videotape reenactment at the scene, and there was even testimony from Tessamere against him. He had discussed the plot in advance, and he had later bragged about the crime to friends at school. He was found guilty and given the death penalty. The case history of this course. Roper versus Simmons' ruling was delivered because of a previous case, Stanford versus Kentucky, in 1989. It was a case that sanctioned the imposition of the death penalty on offenders who were at least 16 years of age at the time of the crime. This decision came 1 year after, in which the court had held that a 15-year-old offender could not be executed because to do so would constitute cruel and unusual punishment under the 8th Amendment. In 1989, the court found that minors can be subject to the death sentence only if charges warrant execution. The court found that capital punishment sentences for minors between ages 16 and 17 did not violate any rights awarded by the 8th Amendment. Another very important case that links to this case, 1988, Thompson versus Oklahoma, the Supreme Court ruled that executing persons for crimes committed at age 15 or younger constitutes cruel and unusual punishment in violation of the 8th Amendment. In this section, we'll talk about the 8th Amendment, the majority opinion, and the court's final ruling. The background of the 8th Amendment comes from obviously, the U.S. Constitution, which states excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Focusing on the cruel and unusual punishment of the 8th Amendment, it's important to remember that the cruel and unusual punishment links to an excessive or disproportionate area to the offense that is committed. Christopher Simmons, he believed he did not deserve capital punishment since he was considered a minor when he had committed the murder. Roper argued that evolving standards of decency prevented the execution of an individual for crimes committed before the age of 18. A majority of the Supreme Court agreed with Roper and held that to execute him for his crime would violate the 8th Amendment. This brings us into the majority opinion, and I added some dissents because they were very important in this case. So the majority opinion was given by Justice Kennedy, And in his majority opinion, he relied on the court's independent judgment and the international law to conclude that these evolving standards prohibit execution of juveniles. There were also two justices who gave the dissents, Justice O'Connor and Justice Scalia, and they wrote two separate dissents. First being Justice O'Connor. In her dissenting opinion, Justice O'Connor had expressed concern regarding the establishment of a categorical rule prohibiting the execution of any juvenile offender. She acknowledged that adolescents as a class were less mature than adults. However, she did note that many state legislators allowed for some 17-year-old murderers to receive the death penalty. She challenged the court's majority assertion that there had been a significant change in society's rejection of the juvenile death penalty since the court's Stanford ruling in a previous case. Justice O'Connor strongly challenged the majority's opinion that juveniles could not reliably be classified among the worst offenders, and therefore the death penalty was disproportional to any crime that they may commit. She wrote, and I quote, "It is beyond cavil that juveniles as a class are generally less mature, less responsible, and less fully formed than adults." It's important to understand the 5 arguments that challenge the premise that juveniles should be categorically excluded from capital punishment because the death penalty was disproportionate. First, she had stated that there was no actual evidence to support the claim that 17-year-olds only rarely demonstrate sufficient maturity to act with such depravity to warrant the death penalty. She secondly noted that chronological age is not a perfect measure of psychological development and argued that many 17-year-olds are more mature than some adults. Third, she had distinguished 17-year-olds as a class qualitatively and materially different from those with mental retardation or intellectually disabled, is what we should be saying, noting that although 17-year-olds may be less mature, they do not have clearly defined defects in life impairments observed in those who are intellectually disabled. Fourth, she expressed confidence in the jury's ability to weigh a juvenile's immaturity during the individualized sentencing phase, and therefore argued that juveniles do not require categorical exclusion from the death penalty. Fifth, she did not find sufficient evidence to support the claim that juveniles' immaturity would render the goals and the retribution of deterrence meaningless. Justice Scalia wrote a separate dissent joined by 2 other justices. He preached that the majority's finding that a national consensus against the juvenile death penalty had developed over the last 15 years throughout the court system was based on, and I quote, "the filmiest of grounds." Justice Scalia argued that the real issue was not a national legislative change against the juvenile death penalty, but the court's substitution of its own judgment that juvenile murders are never as morally culpable as adults. He questioned, and I quote, "By what conceivable warrant can 9 lawyers presume to be the authoritative conscience of a nation?" He accused the majority of picking and choosing those scientific and sociological studies that supported their position that juveniles are not as morally culpable as adults. So the final ruling, 5 votes for Simmons and 4 votes against. The legal provision being the 8th Amendment under cruel and unusual punishment. As we go into the rational. So, the rationale to the rulings. In a 5-1 opinion delivered by Justice Anthony Kennedy, the court ruled that standards of decency have evolved so that executing minors is cruel and unusual punishment, prohibited by the 8th Amendment. The majority cited a consensus against the juvenile death penalty among state legislators, and its own determination that the death penalty is a disproportionate punishment for minors. Finally, the court had pointed out to overwhelming international opinion against the juvenile death penalty. This moves us into the area of how has this case, Roper versus Simmons, influenced specific areas, especially in our society. So American society has struggled with the question of whether a teenager is capable of possessing criminal culpability, warning the death penalty. Often, the juvenile death penalty involves arguments of morality. Is it right to execute a juvenile? Does a juvenile death penalty stand in conflict with the standards of decency in today's society? These questions, they circle around an increasing global society as America remains one of the last countries with a juvenile death penalty. The Supreme Court's decision in Roper versus Simmons significantly has impacted not only society's young people, but also America's position and status of the world. So youth in America today, how does it affect the youth in America today? So since the reinstatement of the death penalty in 1976, 22 offenders who were juveniles at the time of their crime have been executed. As a result of the ruling in Simmons, there were 72 death sentences that were canceled for other crimes that were committed while younger than the age of 18. The greatest impact was in Texas, where 29 juvenile offenders were waiting execution, and in Alabama, there were 14 waiting for execution. In reaching this closely divided decision, the court continued to trend of carving out categories of individuals to be excluded from the death penalty sentence. And this will bring us into our next area for future trials. How has this trial dictated future cases for juveniles in the court system? So we have to think about what degree might this extension continue. Because the court relied heavily on the declaration that juveniles were morally less blameworthy due to developmental immaturity, increased impulsivity, and increased vulnerability to peer influence, this logic might hypothetically be extended to other classes of individuals. So, for example, one could argue that an immature 18-year-old with a low IQ, being borderline intellectually functioning, is less morally capable than a 17-year-old with an IQ of 110. Likewise, a person with schizophrenia, say, may have impairments in reality testing and cognition that interfere with his or her moral reasoning, thereby making him less blameworthy. Will the court one day consider a categorical exclusion of all individuals with mental illness from the death penalty, despite the brutality of their crimes? The foundation of this has been laid because of this specific case. Here's one set of my resources. Here's the second set. And I appreciate you taking the time to listen. Take care.